Thank you for joining us today. I'm Catherine Nash, and I chair Lathrop GPM's Labor, Employment, and Higher Education Practice Group. I'm based out of our Minneapolis office, and I will be moderating our event today. We have some great speakers and presentations lined up for you today, starting with a keynote on trials and litigation in a post-pandemic world with Judge Michelle Childs. Then we will hear from Gize Hirsch, an immigration lawyer, on immigration updates, followed by an insightful presentation on the Midwest Innocence Project. And we will close out the day with a discussion on the ethical considerations of remote work and other post-pandemic issues by Bridget Romero and Peter Daniel. A couple of housekeeping notes before we get started. We will welcome your questions throughout the presentation today. If you have a question at any time, please use the chat feature to submit those. We'll get to as many as we can. We would be happy to follow up with you after the webinar if we are unable to answer your question during the presentation. Our webinar will be recorded and available on our website by Monday, along with a copy of the slides. You will all receive a follow-up email directing you to that page on our website, and we welcome you to share with others in your organization. CLE credit has been sought in California, Colorado, Illinois, Kansas, Minnesota, Missouri, and Texas, and we will be sending follow-up information upon approval. We will kick things off today with our keynote presentation discussing trials and litigation in a post-pandemic world. We are thrilled to have the Honorable Judge Michelle Childs with us today. Judge Childs was appointed to the United States District Court for the District of South Carolina in August 2010. She holds a Bachelor of Science degree in Management from the University of South Florida Honors College, a JD from the University of South Carolina School of Law, a master's degree in Personal and Employment Relations from the University of South Carolina, a master's of Judicial Studies from Duke, and an honorary doctorate of public service from the University of South Carolina. Prior to serving as a U.S. District Judge, she served as a circuit judge, which included responsibilities as the Chief Administrative Judge for the General Sessions and the Business Court. Judge Childs also has the distinct honor of receiving gubernatorial appointments as a Workers' Compensation Commissioner and the Deputy Director for the South Carolina Department of Labor, Licensing and Regulations Division of Labor. Judge Childs is very active with various local, state, and national bar organizations, as well as community organizations. She's actively involved with the American Bar Association and currently serves as chair of the ABA's Judicial Division. This presentation is going to be a Q&A format with Lathrop GPM partner Rick Bean leading the discussion. Rick is a partner in our litigation and dispute resolution practice. He's based out of our Kansas City office. His litigation practice involves defense of class action claims and other claims for financial services companies, employee benefit plans, life, health, and disability insurance defense, ERISA, ESOP, trust company and financial litigation, insurance and professional liability litigation, and insurance coverage litigation. Rick is also actively involved with the ABA, serving on various committees. Without further ado, I will turn it over to Rick and Judge Childs.
Thank you, Catherine. In my first trip to South Carolina many years ago, I learned the way that you greet a guest. Judge Childs, you honor us with your presence. I believe it was maybe a former partner of yours at Nexon Pruitt who greeted the group that way. You heard a little bit about Judge Childs' background, and if that wasn't exhausting enough, let me tell you what else she's been up to recently. In addition to serving as chair of the Judicial Division this year, she's secretary of the Labor and Employment Law section in the ABA, which means she'll go through the chairs in that section. She previously served on the Litigation Section Council and may still serve in that capacity. She was chair of the Federal Trial Judges Conference of the Judicial Division prior to her running through the chairs of the Judicial Division, and is chair-elect of the Federal Judges Association. And during the pandemic years, she has been on the ABA's Special Task Force for COVID response. And if that isn't exhausting enough, she is a spouse, a mother, and has a full docket. So we welcome you and we thank you for sharing your time with us. We know your time is the scarcest commodity that you probably have right now. Uh, Before we get into the substance, which is really trials and litigation, what it's looked like during the pandemic and what it may look like after the pandemic expires, want to learn a little bit more about you. We've heard the resume. We know in our firm, some of our partners have been called to judicial service at the federal and state level, and many of your colleagues refer to judicial service as a calling. How did you receive your call, and what was your path to the judiciary?
Thank you. And thank you first, Rick, for allowing me to have this wonderful invitation from yourself, from your firm, and also for your invitation to several other of your clients, in-house counsel, and generally the public. This really shows a concern about the courts. It also shows our shared responsibility in the fair administration of justice. So I really appreciate the opportunity to be here. Insofar as my path to the bench is concerned, I started out as an associate at my former law firm, Nexon Pruitt, and then eventually became partner. Within 6 months of being partner, I actually got a gubernatorial appointment to run our state's division of labor. In that process, I had 100 employees under me, and I had 6 programs under me. Then I thought I was going back to my firm as a partner, and then got another appointment from the governor to be a South Carolina Workers' Compensation Commission. In that role, we serve as hearing officers to decide cases for injured workers, so it's a quasi-judicial role. But then we also serve as an appellate panel to review the decisions of our other co-commissioners in that regard. I then became a state circuit court judge. In that role, we are one of the few states, just South Carolina and Virginia, that actually have to go through the General Assembly to actually get elected, as opposed to a public election or an appointment. So once I became in that role, I then came over to federal court and basically got a cold call after President Obama was elected to office to see if I might be interested. And of course I said, sure, but I also thought that you had to be doing a lot of fundraising, a lot of political activism, and I had done neither. And so I was just asked to send in my resume, and then a few months later, I found out that I was being nominated to the president to be considered for a United States District Judge. So it has been a wonderful path to public service once I left the private firm, and I really do enjoy public service.
Well, you certainly have done some unique things. You may be one of the only judges in the country who has been in the administrative judiciary, the state trial judiciary, and now the federal trial judiciary. And in addition, through your bar service, and in particular in the pandemic response task force, you have gained a national perspective on how judges and courts have responded to the pandemic. From this broad range of experiences, how have courts, in what you've observed, responded?
Well, that has been an honor serving as chair of the American Bar Association Judicial Division. And just to give the audience some perspective, we are the voice of the judiciary with respect to any lawyers and judges who are in the American Bar Association. And of course, that spills over into other organizations and just justice generally. We are comprised of trial and appellate judges and lawyers, specialized court judges, administrative law judges. We have a tribal courts council as well. And then, of course, as I indicated, state trial judges, federal trial judges, and then, of course, the appellate judges. That gives us an opportunity to see how courts work and to be at the forefront of all levels of courts in that regard. So once the pandemic came into effect, and that was around February of March of 2021, I remember our last meeting being at the mid-year meeting in Austin. And then I remember going to speak in New York to actually teach federal judges with respect to being on a panel for employment law, which was my prior background. And then I was going to be heading to Duke because I do multi-district litigation, and got a call on the way to the airport to say Duke conference canceled. So things got very serious, and then the world started shutting down. So we had to ramp up and immediately get responsive in that regard. So the year that I had planned for my bar year to start last August of 2021, and of course, as a chair-elect, you plan well in advance, we had to quickly envision everything to be virtual and remote. And so in that regard, the courts were also being responsive. In my particular court, We got on the calls with health specialists, the state epidemiologists, because if you'll recall, the initial concerns with COVID were just touching, just any kind of trace contact. And, we now come to know that that's not the case, with respect to surfaces and things. But we were also very careful about, what is this, disease and this pandemic in that regard. So we were acting by shutting courts down mostly around the country, and our court did it for around 60 days or so. By then we had more information, and then we started leaving it up to the individual judges to handle their court docket. With respect to the ABA coronavirus task force, the Judicial Division already had a court technology team, so we were already trying to implement more efficient processes with court with respect to backlogs. But this task force has been absolutely wonderful. It has collected resources from around the country. It has collected standing orders. It has collected best practices. You can still go to the ABA Judicial Division website to find all of that wonderful information with respect to how courts should function. And our new focus, obviously, will be how courts should go further and collecting some of the best practices and continue to operate now.
Well, from what you've seen and collected, especially in those best practices, what's your observation about what do you think was the most creative or significant or innovative action taken by a court that you've seen, or court administrators?
I think one of the things that has made us all more conscious of is just our time. Our time and resources with respect to how we practice law. Many people were traveling, and I'm sure when I listened to your resume as well, it has to be taking you across the country, and it has to be taking you across the country for sometimes 20-minute or 1-hour hearings. And that's just not efficient in court. So I think we're starting to realize that at least for some of the less complex cases, status conferences, perhaps some of the motion hearings, that we'll need to be looking more forward to doing those types of things virtually. I will say that once we open back up, I've been having trials all along. And so I've just learned how to work with lawyers as partners in this system to keep the fair administration of justice and work through how we'll do the trial. For example, if there's an expert witness who had some issues with COVID or, was concerned about their own health, then we would have to use the video. And lawyers will now need to kind of pivot and understand that you may be taking depositions, but they'll be for the purpose of actually showing the jurors the video at trial because those witnesses may not appear there. We'll also do differently with how we use evidence. In some of the trials, we're using only electronic evidence. The only paper that is passed is actually to that witness. That witness gets their own copy. We get our own copy as the judge and perhaps the law clerk and the court reporter. So there's a few more copies there, but the juror doesn't touch any paper. So that is something that we have to think about. And just a quick funny story, when I was in one of the trials, there was a senior lawyer who had come in, ready to try the case, but the junior lawyer had really worked up the case. The senior lawyer noticed at the trial that there was no paper and kept asking, when are the jurors going to see the evidence? Why aren't we passing the evidence? But because that's what you're used to. But I said, we have been doing it. It's just on the screen. And then they'll get a disc. They can pull it up. They can come back out here to look at it, or they'll, have the capability in their courtroom. So there will be getting some used to as things progress and move differently.
You've talked about a number of things that have changed as a result of COVID. Are there any of those that have caused you to ask, well, why the heck didn't we do this before?
I will say that the need for being in person on everything. Now, naturally, on the side of criminal defendants, they have the right to be with their counsel in court. But even then, I did a couple of guilty pleas maybe a couple of weeks ago where the defendants were out of state. Well, we worked out video conferencing for them. We've done that in some measures just when they've asked for it, but I think it's going to be more appropriate in some of your less complex cases where perhaps the person and everybody has an agreement that it's going to be probation, to just not bring people in. They've moved on, they've flown across the country, set up life somewhere else. So we need to really be thinking about, do we have to require everybody to be in court for every situation?
So your trials were all live and in person. You didn't do any web trials, correct?
No web trials.
Okay. In your
And just to give you an idea,
yeah.
one was a 2-week public corruption. Another one was a product liability case. Another one was a criminal case with drugs. And then one, I believe it was employment or breach of contract or something. So it runs the gamut. It's the same cases. It wasn't as if I was focusing on only certain types of cases could be there. And then to give you an idea of the setup, we have on our questionnaire added some particular questions. Anything related to COVID, we allow jurors to opt out of. If they don't even want to spell the word COVID, then that's fine, because we really don't want them to feel at risk of being here. Then when we get back here, I make sure that in my preliminary jury instructions, I let them know that their safety and health concerns are ultimate for me, that we will make sure that they're okay. Everyone wears masks unless you're speaking. We have plexiglass within the juror box. We have plexiglass at the tables for counsel. I have plexiglass around me from the court family presenting anything to me, the witness or my law clerk. Even when the lawyers come at sidebar, there's plexiglass there, and there's more microphones along the way so that they can spread out, because it would be, disruptive to have to keep sending the juror out in that regard. There are microphone guards there, and jurors are separated in the various jury rooms until they deliberate, which we then put them in a huge jury assembly room where they can actually spread out, because you're not supposed to be talking about the case anyway, obviously, too. So we have found that working through all of that has been fine. And then, of course, lawyers will jump up and say, well, wait a minute, I want to talk to my co-counsel. We're both vaccinated. Well, we just still make it safe for everybody. And we've issued them walkie-talkies, actually, to be able to communicate. So, we have a little fun with it in the sense that we will get you what you need, but it might not be in the format that you perhaps would like.
Yeah. I mean, those are interesting and innovative ways to handle it. One thing I noticed, I had an in-person all-day hearing in U.S. District Court in Florida last September or October, and the cleanup was do-it-yourself. There was spray and disinfectant around. Is that the way you approached it as well?
Yes, essentially.
Yeah.
And then the court deputy will go clean off behind every witness after the witness stand. We make sure everybody brings in their own bottled water. We give the witnesses their bottled water and make sure that they take it away from them. And then I do allow, because again, we can handle our own courtroom, we give our lawyers their own attorney rooms, and then allow them to bring in snacks and waters, because we realize, with the masking that can be difficult. And then you don't know people's health situations as well. But yes, it's basically, here's the spray on the table and everybody go for it themselves.
How did you handle the public's right to just walk in the courtroom and watch a trial?
Well, what we do is count the availability of the seating within the courtroom. And so when I have 2-week trials, there might be 4 sets of lawyers. We give each party so many seats. But then the media, of course, has the right to be there. So we will either have a seat for the media, and then we'll also have an overflow room in that regard. We have, as a general statement, stated that no one should be in the courthouse unless you have business here. So we hope that anybody who's attending is actually related in some way to the party. So we're kind of discouraging it. But if anyone insists, then we'll probably send them to the overflow room.
The overflow room has live streaming video, I assume, audio. Yeah, okay.
Yeah. So they'll see it, again, not in the format that they perhaps would like, but they will still have that opportunity, because we've been very sensitive to that. And the media generally obviously covers the story in, their way, but that lets the public know what the case is about.
In the 4 trials that you mentioned, were those all jury or were some of them non-jury?
They were all jury trials.
Okay. Well, sticking with that theme or the idea of the jury trials, let's take a look from your perspective, both in your own judicial practice, your courthouse, your courtroom, and what you've seen nationally. And you foreshadowed this a little bit, what do you think is sticky? What do you think is long lasting out of these innovations developed out of necessity from response to COVID?
I believe that each court will continue to work with the health specialist to determine what is appropriate for their particular courts. I'm very fortunate in federal court. You see the Matthew J. Perry Courthouse behind me, and each of us are assigned our own courtrooms So all of the judges can come up with kind of their rules. And even most recently, we indicated that while we require the public to walk in with masks, if lawyers come into our courtroom and there's only two of them and there's a motion hearing, then we can allow them to unmask. We usually do it only for speaking, so things like that. I think it's going to require us, which we have been doing, to just continue to be very thoughtful and deliberate to individualize it to the situation. Now, when you're in lower courts like magistrate court and perhaps state court, they're much more crowded. So I think that I've seen, at least in our state and across the nation, standing orders where court has not been opened up. And so those cases will have a lot of backlog. I did not want that to happen because there were several lawyers who were ready for trial. And if they did not want trial, as long as there was an agreement, we would push their trial off. But there were several lawyers who needed to be on a docket for resolution. The other thing I see is that lawyers are now having to talk to each other a lot more, and they are using alternative dispute resolution for purposes of the mediation, because many of those will be conducted by video conference. And then that's very helpful and efficient in that regard too, because again, usually the adjuster may have an agreement to be on the phone or by video, but in some cases not. And so they were having to fly in. I also see that we will be looking harder at which cases actually need to be in front of the court. I had a multi-district litigation right now, 26 or so class actions in that regard. Rick, I'm surprised you're not in that case. But in that regard, I have allowed people to be on telephone or video or in person, and we send out the notice that way. You are not going to be penalized because you didn't show up in front of me. I mean, I'm going to rule with respect to the record, but I'm going to also, again, respect people's time, because you may come across the country for our status conference, which might last an hour and a half, and we don't need to be doing that. So I'm going to keep that practice going forward. And when we've had to reschedule things, then lawyers, also have dockets, and I'm respectful that the best lawyers, they're busy literally around the nation, that it's okay for them to be on the phone with me. And it's not, to me, a sign of disrespect at all, because that's an option that I'm offering. And we will also have, the electronically filed evidence. We will, while federal court has the electronically filed docket, I believe the state courts are coming along in those jurisdictions that didn't have it and requiring more electronically filed documents instead of, as I remember in state court, when I had a non-jury week, they would roll literally all the files to my office and in envelopes and, boxes and things of that nature for me to touch everything. But now I can just go in the system, literally even on my phone, to grab my cases.
Yeah, I think the electronic docketing is spreading. It's mainly in the state courts. It's mainly a funding issue for most state courts, which has been the challenge. Missouri has had it for several years. Kansas has it, but not across the state. It's a county by county thing, which is somewhat problematic. You talked a little bit about video conferencing for routine hearings. What about substantive motion arguments? Did you use video for that as well?
I have done that, for summary judgment motion, which still had a lot of exhibits or depositions, things of that nature. And the briefs would already be ahead of, we would have those early. So we would have everything that we needed to go through. The lawyers would argue just the same in terms of referencing. I would only need my IT person to remain in the courtroom, obviously, during the hearing, just because if there's a glitch, then it's not up to me to try to figure that out, but that person would be much more capable in that regard. I will also direct you to the Arizona Supreme Court. They put out a white paper that is, I think it's titled Post-Pandemic Recommendations, and it's got a lot of things in there with respect to innovation. So I would urge you all to look at that, as well as the ABA Judicial Division website. Some of the things that also come up are remote notarization services. There are also a lot more self-service kiosks. And of course, those are probably more so in the lower courts.
You mentioned mediation by video, which I think has been, at least in our jurisdictions, ubiquitous. I mean, all the mediators embraced it. It reduced their travel time. It made their lives easier. In your court, do magistrates or bankruptcy judges conduct court annex settlement conferences?
Well, as a matter of routine, the parties will try to mediate along the way. What I do is right before trial, when we've got a trial date that may be about 3 months out, is get my courtroom docketing clerk to ask the parties, would they like to consider mediation through a magistrate judge? And then there are some magistrate judges who have volunteered to do so. And it's not for everybody, it's a skill in and of itself as well. But they've been very successful in resolving cases as well. One thing that they do, because their time is valuable, they're writing a lot of orders as well. They generally give you about a 3 to 4 hour window, so you can tell if that case is going to settle or not. It does not get dragged out. They get right to it in terms of is that case going to resolve itself.
Have they used video for the court annexed mediation or settlement conferences?
Yes, they have. And I think they, again, make that up to the parties, and they look at travel constraints on, parties depending on where they're coming from.
Turning to remote testimony, and you indicated that is within the sort of overall docket and case management issues that Rule 16 allows you to implement. So far, has remote testimony all been consented to by the parties, or have you ordered it, and have other judges ordered it?
In the first trial that I had, and one was actually professional legal malpractice, the expert asked, even though he lived in Columbia, South Carolina, asked to come remotely, and then the parties, be on remote, and the parties consented to that. But I have had motions filed with respect to requiring remote or in-person deposition on deposition. So I have had to rule on those. The rules accommodate that, but of course there can be objection to that. And I've looked at that on a case-by-case basis to kind of see what the issues were. Because you lose some things with this, obviously, the ability to watch body language. There are concerns about professional ethics in terms of is the witness being coached? There are concerns about whether the lawyer should be able to be next to the witness for that very reason. So you really have to look at those on a case-by-case basis.
You also talked about the advantages of appearance by video, testimony by video. On a net basis, do you think the advantages outweigh the disadvantages of requiring everybody to be there in person?
I do, but there are a couple of exceptions. One would be persons with disabilities. Just because there are certain issues about how they may portray themselves, they're feeling like, are they getting true access to justice by not being able to be in front of the court, in front of the judge, and just general accessibility issues. You also have the issue with respect to perhaps criminal defendants who would want to be right next to their lawyer, because if a judge is asking a question that they need to speak with their lawyer about, then they want that immediate ability. I've handled the latter issue more so with allowing the lawyers to perhaps appear in the courtroom an hour before me if they're not going to be next to their client, obviously the client's at the jail, so that they can just have a discussion about whatever it is they need, go back over everything, even though the lawyer would have visited with the client in the jail. And if there's a time during the proceeding, as I always allow the parties to talk with each other, then I will excuse myself from the room, just again to make sure that they have that opportunity. So we're all adjusting along the way as necessary. But to answer your question, I do believe that there are a lot more benefits when you're looking at time and movement of the docket and being more efficient with our court processes.
Let's turn to a topic you mentioned earlier, which is vaccination. It's available everywhere. Another one was just announced today, which would be the fifth vaccine, a 2-shot regimen that's supposed to be about ready to go. Has the Judicial Conference taken a position regarding vaccinations for judges and court personnel?
I don't think that there's an official position. I do know that generally courts are doing a lot of encouragement. In fact, we had our U.S. Marshal trying to encourage inmates to get vaccinated, because we're getting so many compassionate release requests about, not coming, when that could be one of the things that would help when they're wanting to be released. We're also encouraging it for probation officers who are out in the field, in that regard. And then with respect to jurors, we've not asked the questions about whether you are or aren't because we're requiring them to have all the social distancing practices in place. And I believe that you will start to see, at least with respect to criminal defendants, perhaps even incentives, just like everyone else is offering incentives, that there might be some incentives with respect to their sentence, a couple of months off or what have you. But nothing formal. I think that's going to be studied more. But what we feel like we need to do is continue to make it available. Like if people aren't taking it, what can we do to assist in making it available?
You mentioned some of the best practices and rules. Those are available on the ABA Judicial Division website. Is that correct?
Yes, and I will say that we've done so much in terms of educating people about some of these issues. One of the banner items of my year has been ABA Wellness Wednesday program. So I started out with coping with COVID, just kind of a judicial checkup because we are already isolated. Wanted to make sure our health, mental and physical, is fine. Other ones are judging during the pandemic, what judges and lawyers and jurors think about remote proceedings and the future of court operations. We also have remote jury trials during and after the pandemic, constitutional and practical concerns. One on hearings and trials and the effect on persons with disabilities. Also, is your court ready for the next disaster? Some of these come in the form of podcasts as well. And then courtroom communication during the crisis and COVID-19 and victims of addiction, mental illness, and domestic violence. So again, all of these are coming out of our work through ABA Judicial Division, as well as the COVID Rapid Response Task Force, just to give people cutting edge best practices as we go along.
And for our audience, we will email to everyone who attended these sessions a link to the JD page and a link to the Arizona Post-Pandemic Innovation Order, which I thank you for reminding us about, Judge. We talked a little bit about public access, at least in your courtroom. It looks like, although no one can be certain, that this isn't going to be a one-time event, that the COVID variants are going to continue. Booster shots may be required. There may be other similar diseases. From a public access standpoint, do you think that points toward a trend for either expanded broadcasting or webcasting so that the public has access to proceedings?
And as you all mentioned, I was a state trial judge before I came onto the federal court. In state court, because of the nature of the matters that we had, I was so used to media being right in the courtroom, naturally for a lot of the criminal cases. So I think that they would take up that banner quicker just because they were already broadcasting certain of the proceedings. Obviously, you wouldn't let the jurors be seen, on television and things like that. But otherwise, I believe they'll be in that regard. Federal courts having cameras in the courtroom has been a non-starter for many years, as you're aware. And so I think that there will still be that fight to not do that. If any broadcasting, it would be by sound, most likely.
All right. We have time for one more topic that may not sound completely related to our overall topic, but I believe that it is. You would expect that during the pandemic, judges were safer because courthouses were empty, people were not around, but the evidence indicates that's not the case. Almost a year ago, the tragic death of Daniel Andrell, the son of Judge Esther Salitz of the District Court of New Jersey, was killed. Her husband was injured in an at-home attack. The Marshals Service, in its 21 budget request, indicated that over the 3 years previous, inappropriate communications, incidents, and direct threats had increased by more than 40%. It seems that, at least at least at the federal level, most of these attacks have taken place away from the courthouse. We don't seem to be getting along any better in society. And unfortunately, state and federal trial courts and appellate courts come into some criticism from various components of our society. Judicial security is a significant issue. What are some options that, based on your experience, both as a judge and in your leadership positions, you think policymakers should consider in improving judicial security?
Well, let me thank you again, Rick, because you serve as our resolutions committee chair with respect to the ABA Judicial Division. And through that process, we sent a lot of resolutions to the House of Delegates, which is the policymaking body of the ABA. We also comment on other legislation or proposed resolutions that can lead to legislation by other groups. And so I actually got to work a lot with respect to the Judicial Security and Privacy Act that's going through now as a result of what the very, very unfortunate incidents with Judge Salas. And as you indicated, this was by a lawyer who was upset about a ruling in her courtroom and then disguised himself as a driver and then came to her home. And so, yes, there has also been an uptick in over 40% of these particular incidents. I do believe the legislation will be helpful. And what we're looking at is really being concerned about scrubbing a lot of our personal information off of the internet, in addition to the upgrade of the security systems in that regard. As with everything, it's a funding issue, but it's also a very serious issue because as I'm aware of, just over the last course of at least the last 10 years, 4 judges have died. And then some have obviously had family members who have died as well. But I do believe the legislation will help. I do believe we're getting some traction on it. And I really do hope that in this Congress that will go forward.
Judge Childs, thank you very much for generously sharing your time, your experiences, your perspective from a national perspective, and especially your perspective as a trial judge at the federal level. We thank you again. We can't express our gratitude enough.
Well, you're welcome. And thank you also for partnering and putting on these types of programs that allow us to share in the knowledge about what's going on with the court system, because we're all constituents and users of the system. So thank you so much.
Thanks. Catherine, we'll turn it back to you.
Thank you both for such an interesting conversation. It's great to get insights as to what the court is trying to do as it navigates conducting these hearings and trials now. And I think many of us who litigate are hopeful that Judge Child's approach will be what other courts are doing as well. It could be another one of the silver linings in COVID-19 that we are adapting and developing better procedures. Next, we have Gize Hirsch, who works with me in our labor employment group. Gize practices in all areas of business related to immigration law. She assists national and local employers such as architectural firms, educational institutions, manufacturers and entertainment firms, financial service firms, and healthcare providers with immigrant and non-immigrant matters. She focuses her practice on representing employers before the United States Citizenship and Immigration Services, the Department of Labor, and the Department of State on a wide variety of immigration matters. I personally am so pleased that Gize is a part of our team because the insights and information she has is just so useful to our clients as they navigate these areas. I'll turn it over to Gize.
Thank you, Catherine. Hello, everyone. I am very excited today to be talking to you about immigration and specifically immigration in under the Biden administration. So it's no news that the Trump administration had tough immigration policies that affected every aspect of the immigration system, be it business immigration, family, or humanitarian. There were not a whole lot of legislative changes, but a sweeping shift in policies through interpretations, decision-making, and obviously a slew of executive orders. The Trump administration reportedly implemented over 1,000 measures in the 4 years that it was in office, including many changes impacting legal immigration. For some perspective, that amounts to about one immigration action per business day, per each business day that the administration was in office. So pretty remarkable if you think about it. So what are the steps that the Biden administration has taken so far in the 4 months that it has been in office to roll back some of those measures? Days after taking office, the Biden administration eliminated the Trump era Buy American, Hire American, also called BAHA, executive order, which BAHA directed heads of agencies to issue rules to protect US workers through administration of the immigration system. I would say that was, in terms of policy changes on immigration, on business immigration, that likely was the most impactful. It became the foundation for many restrictive immigration policies. It prompted federal agencies to issue numerous policy memos, resulting in substantial changes in how immigration benefit petitions were being processed. We saw increased denials of work visa cases, increased requests for evidence, and other cases. The other change, big change, and this happened on the first day that the new administration took office, was it overturned the so-called Muslim ban, which had barred entry of foreign nationals from 13 predominantly Muslim and certain African countries. And like I said, that was repealed on the first day that the new administration took office. The first and second versions of the same so-called Muslim ban were struck down by judges who held that it amounted to religious discrimination. But there was a third version of the ban that was upheld by the Supreme Court. And the other change, next slide, please. Another big change, and this also affecting business immigration, is that the new administration has rescinded what's called the public charge rule. What the Trump administration did was require those seeking US permanent residence, and it could be individuals seeking US permanent residence based on employment, to complete a declaration of self-sufficiency, to prove that they're not going to be a public charge, or that they are less likely that they're going to benefit or take advantage of public benefits. So in the employment permanent residence cases, what that meant was having to submit pages and pages of financial data, including bank statements, credit reports. We were even required to submit credit scores, just to show that these, already high earning foreign national employees were not going to be public charges. Similarly, non-immigrants, including H-1B and L-1 workers, were required under the Trump administration to answer public benefit-related questions to determine their eligibility. And those questions have since been eliminated. The Biden administration also rescinded the immigrant visa ban, which was put in place due to COVID. And then it let a similar non-immigrant visa ban expire. And what had happened was there was suspension of entry of certain immigrants and non-immigrants into the US in light of the pandemic, on the premise that they will hinder the country's economic recovery. Interestingly, although these COVID-related non-immigrant and immigrant bans have now been lifted, we're now having to deal with geographic travel restrictions that are significantly affecting travel to the US. And in fact, what the Biden administration has done is extend those COVID-related, public health-related travel restrictions that were put in place for the UK, Ireland, Iran, the 26 Schengen area countries, China and Brazil, and also added 2 additional bans to South Africa and more recently to India. So there are now 4 presidential proclamations in place, 2 by the previous administration and another 2 by the current administration, suspending entry in the US of all non-citizens who were physically present in in one of these 33 countries for the 14 days preceding, physically present in one of those 14 countries during the 14 days preceding entry or attempted entry into the United States. The US Department of State was continuing to issue visas despite these original restrictions, but it recently abruptly stopped issuing visas. There are exceptions, of course, to these restrictions, and there are waivers based on a national interest exception. And perhaps what distinguishes the previous administration from the current administration is that the criteria for these national interest waivers and these exceptions seem to be continuously expanding. And hopefully with people getting vaccinated throughout the world, the hope is that these restrictions will go away, or we're going to see a much expanded waiver and exception criteria. Also worth noting, and something that has become a huge challenge in terms of travel to the US, is a huge backlog in terms of visa processing at the US embassies globally due to all of these restrictions in addition to the COVID-related restrictions. Again, there are standards for requesting emergency visa processing, but needless to say, meeting the requirements for those exceptions is not always easy. I don't know if I have more time. If we can go to the next slide, I would just want to spend a minute or so talking about changes in humanitarian immigration. Again, the first day that the current administration took office, it directed the Department of Homeland Security not only to preserve DACA, the Deferred Action for Childhood Arrival, but also strengthen it. DACA is a program that provides relief from deportation to certain undocumented immigrants who came to the US as children, as well as grant them employment authorization. The administration has also vowed to increase the refugee quota and reverse policies leading to separation of families at the border. In terms of the refugee quota, it was the lowest under the Trump administration at 15,000, and that was the case. The cap remained, I want to say, until the beginning of May this year, when the current administration increased it to a little over 60,000, with a promise to increase it further and to up to 123,000. Again, the first day that the current administration took office, it also proposed a comprehensive immigration bill called the Citizenship Act of 2021, which, among other things, it's going to have a sweeping change to the overall immigration system and also provide paths to permanent residence and citizenship to DACA beneficiaries, immigrant farm workers, and others. And of course, it remains to be seen whether that bill is going to get gain any kind of traction. In conclusion, one takeaway just in observing the changes that have come about in the 4 or so months that the current administration has been in place is that certainly there have been changes that affect business and employment immigration, but the priority, at least the immediate priority, appears to be on humanitarian immigration. That is, border issues, asylum, and also a refugee resettlement.
Thank you, Gize. That was great. If anyone has any questions, please feel free to reach out to Gize directly. Although she focuses on business-related immigration law, she is also a critical component of our firm's pro bono work to obtain asylum for dozens of clients who are fleeing persecution in their home countries based on their race, religion, gender, political opinion, sexual orientation, or other protected class status. At our firm, we believe the privilege of practicing law comes with the responsibility to ensure that everyone has access to the legal system, regardless of resources. We take pride in using our legal skills to help people in need and are honored to work with legal service organizations and nonprofits in each of our office locations to represent the most vulnerable among us. At Lathrop GPM, some of the core areas where we focus our pro bono efforts include helping the wrongfully convicted, which you'll hear more about in just a moment, asylum and immigration, housing, veterans, and child advocacy. Next, I'm pleased to turn the mic over to my colleague, Matt Jacober, to introduce our next guest speaker.
Thanks, Catherine. As lawyers, doing pro bono work is something we should do because our talents, education, and access to justice is fundamentally different than any other profession or group in this country. Separately, we should do it because it renews our souls, taking us back to some of the lofty ideals we had when we started law school. While I've consistently done pro bono work through my career, meeting Tricia Bushnell and learning the work being done at the Midwest Innocence Project made it all click for me. Our justice system is good in the US, but it isn't perfect. There is no greater crime than an innocent person wasting their life in jail, generally with almost no meaningful access to justice and no hope. Helping to change that course and right a possibly decades-old wrong is rewarding in ways that serving our fantastic clients simply cannot replicate. That is why we are so proud to partner with the Midwest Innocence Project and similar groups like the Great North Innocence Project. We are lucky to have Tricia Bushnell here today to provide you all with an insight into the Midwest Innocence Project's work. Tricia is responsible for managing all aspects of the MIP and serves as its lead attorney, representing clients in court and clemency proceedings. Prior to joining MIP, she was an assistant clinical professor at the University of Wisconsin School of Law, a fellow with the Equal Justice Initiative in Montgomery, Alabama, and an associate at the law firm of Kirkland & Ellis in Los Angeles. She also currently serves as the president of the Innocence Network, an affiliation of 68 innocence organizations around the country and the world. Tricia, we're proud to have you here today. Thank you so much for your time.
Thank you all so much for having me. Just going to give me 1 second. I am going to put some slides up for us all to share today. Hopefully everybody can see that. So thank you, Matt, for those really kind words. It's been a wonderful experience getting to work with you and others at Lathrop. That said, as you heard, I was a law professor. So before I got to that, what we're going to talk about today is the work that we're doing, and specifically the work that we're doing in Missouri, but why the process is the way it is and how difficult it is to bring some folks home. So, sorry, 1 second while I set up my screen. So the Midwest Innocence Project, we represent people convicted of crimes they didn't commit, and we work to bring them home and to change the system to prevent it in the first place, right? I think if everything went our way, if we had our dealers, our whole goal is to work ourselves out of a job. Unfortunately, in the last 25 years, as it's become more and more understood that innocent people are wrongfully convicted, the numbers that's showing from the vast rate of exonerations is that it's actually a striking number. So the studies estimate somewhere between 2 to 5% of people who are incarcerated are actually innocent. And so the Midwest Innocence Project, we work in 5 states, Missouri, Kansas, Nebraska, Iowa, and Arkansas. That means somewhere between 2,000 and 5,000 people in our region are serving time incarcerated for a crime they didn't commit. And when you sort of look at that in the demographics, you can see there are different reasons and different underlying issues in each different jurisdiction that cause these wrongful convictions, right? So you'll see we actually have while we have a very long wait list, there are about 738 people still waiting for assistance from us. The vast majority of those cases come from Missouri, and then next is Arkansas. One of the things that I want to talk about today is sort of why that is. And also one of the questions that we get all the time, which is why does it take so long, right? You hear about folks who've been incarcerated for decades, and you're like, why does it take so long to fix this? And so to get to that, I want to talk about why the system is the way that it is and how our process works to get to it, and why sort of justice is delayed for so long. So the first thing I want to do is just sort of give you a life of a criminal case, because this is the reality that indigent defendants are experiencing every day all around the country. And a reality that's also been delayed for many, as we heard earlier, through the pandemic as proceedings were unable to begin. So the life of a criminal case, we describe it in our work as 9 boxes. So 3 different types of appeals that go up through 9 different boxes. We start down in the bottom left where we go to the trial court. And just like you see on TV, just like everyone learned in law school, the trial court, the defendant has a right to an attorney. Hopefully that attorney is making lots and lots of objections. We tell our law students, if you don't know the grounds of the objection, just say the Constitution, because preserve something, right? Because what happens is when Mr. Defendant loses, and I'm going to use male pronouns because the vast majority of our clients are men, once Mr. Defendant loses, what happens next is it goes up to the next court of the state Supreme Court of Appeals in the state Supreme Court. In this instance, it shows Iowa, but it could be any state, Missouri, Nebraska. And what the court looks at on that direct appeal, where they also still have a right to an attorney, where they have someone who can examine this and look at it and represent them, are only the issues that were preserved and presented by trial counsel, right? This is not shocking to anyone, I think, who is years practicing. This is what we know. You make a trial record, you object, and then you go up on appeal and you say, I'm sorry, but the judge got it wrong. They shouldn't have let this in. They should have let that in. You know, this doesn't make any sense. All of the issues that were preserved that we were arguing about and objected, we think that those decisions were incorrect. But what happens for a defendant is what that means is if new evidence has come in, if other new issues have come forward, they can't raise that on direct appeal, right? They have to go through this process first before they can bring in the information that's new. And so when they go to the next set of appeals that we often talk about, which is called the post-conviction or state habeas appeal, this is the first time that a defendant is able to present this new evidence. And what kind of new evidence? The things that we talk about newly discovered evidence, which can be things like new DNA testing or forensic testing. One of my favorites is, if you're convicted of a murder and the victim shows up alive, that's newly discovered evidence. State misconduct, if the state suppressed evidence that you couldn't have known about and you're just now bringing this forward, that's new evidence. And so what we do is we're telling the defendant, you have to go back to the trial court, to the very court that convicted you. And now in this appeal, you're essentially saying, Your Honor, I have information that is new that I couldn't have known about before. And now that you know about it, you're going to see either that I'm actually innocent or that my trial was unfair and I should get a new trial. One of the other big issues that comes up at this point is what's called ineffective assistance of counsel, right? So they had a right to counsel and they couldn't have known their attorney was doing a terrible job until now they've come forward and done some investigation and seen the things that they were supposed to have done that you can now prove and bring into court, okay? All of these different things. But I think what folks don't appreciate, so varying on the states, sometimes you have somewhere between 90 days and 3 years to get into court to file this from the end of your direct appeal. But the entire time, a defendant is supposed to be finding this new evidence that wasn't presented at court before. They're incarcerated, they're indigent, and they no longer have a right to counsel. So this clock is ticking. All of this information needs to be presented. They're trying to prove that it's unfair, but they have no one to assist them. And when they do, what exactly you're going to see that our client Lamar Johnson, that we represent with Lathrop DeCage, did, where you start your own investigation, where you're getting your own records, where people are sending you affidavits. Well, then the state says, well, you got them, right? As if that somehow makes it unreliable when you had no other option in the first place. So this set of appeals is what's called, the state post-conviction or state habeas. And so by the time someone gets to us, they've already gone through that because their deadline has passed. You also only get one shot at that apple. And then the last set of appeals that someone gets is what's called their federal habeas, which they're only allowed to present all of their federal issues that came up through boxes 1 through 3 and then 4 through 6, where they were federalized. So if this defendant who has no legal training only relied on state law in their post-conviction process, too bad, so sad, the federal court's not going to hear it because it needed to be a federal claim. They also need to file that within 1 year of the end of their direct appeal, unless their post-conviction was filed and it's stopping the clock. So in states where you have things like 3 years to file your post-conviction and a defendant waits until the 2nd year and is timely filed in their post-conviction, too bad, so sad, they have already lost the ability to have a federal habeas. So we raise these because I think there's this misconception that people get out on technicalities. The reality is all of these technicalities, all of these procedural rules, do you have a right to be in court? Has it been preserved before? Did you abandon this issue? Is what are keeping people from being able to have their merits heard. And so, why does that matter, right? It matters because for innocent people, when we're getting their claim, we're looking at their case that's already 20 years old. What is the mechanism to get back into court, right? They're already too late. They've missed every deadline. They've already had an appeal. And what the system says is you only get one. You had your one shot. And for many folks who are innocent, they're filing over and over again, understandably, trying to get home. And so what you just see is the state arguing over and over. There's a procedural bar, without getting to the merits of what's there. So the question then becomes just, how do we get back to court, right? And the reality is this is the part that shows why it takes so long, besides the fact of the lack of resources, for an individual to be exonerated. So the first thing to know is to get back into court, we get to use what's called a gateway claim, which is that innocence is unclear in the federal system if innocence is a reason to get out of prison, but it is a reason to get into court. So in a case called Schlup versus Delo, which went to the US Supreme Court, but was a case here in Missouri, the US Supreme Court said, okay, if you have new evidence that establishes a reasonable probability that no reasonable juror would find the defendant guilty, that is a gateway, that is a showing of a manifest injustice that we will hear your other constitutional claims, okay? So if you can present new evidence, right, of actual innocence, we will hear your other constitutional claims, but you have to have other constitutional claims because the constitutional claim is what's going to get them out of prison. The innocence is what's going to get them into court, all right? So what is new evidence? Well, in every jurisdiction outside the Eighth Circuit, it's just anything that wasn't presented at trial. But unfortunately, in the Eighth Circuit, they found in the case of Ricky Kidd, our client who was exonerated here in 2019 and is now my colleague, that new evidence could only be evidence that wasn't available at the time of trial. So what that meant for Ricky, who had been convicted despite having an alibi, having been at the sheriff's department at the time that the crime occurred, when his trial counsel didn't do the proper investigation to fully develop that alibi and the proper investigation to actually show the three real perpetrators who have always been known since day one who they were, when he went to federal court and he raised his actual innocence claim, solved crime, we know who did it, he had an alibi, the Eighth Circuit said, no, that's not new. Yes, that may be actual innocence, but that evidence was not new because it was available at the time of trial, and too bad, so sad, you had ineffective counsel and nobody got it. So you see, this was a case that happened in 2011, right? Ricky was not exonerated for another 8 years after this, because again, it's not on the merits. It's not whether or not he is innocent. It's, is there a procedural mechanism for him to be talking about this? Okay, so in the US, the federal system, unclear whether or not innocence is a claim. In Herrera versus Collins, essentially the US Supreme Court says, you know, it could be, there's all these different ways, but we haven't seen it. We don't need to address it, right? But if it's not in the federal systems, the states have the ability to make innocence a claim. And in Missouri, they did just that. So in 2003, in the case of Joe Amrine, the Missouri Supreme Court said, because there was no credible evidence remaining from the first trial to support his conviction, not only was Joe, who had been sentenced to death, released from death row, he was exonerated. So Joe had been convicted based on a number of different eyewitnesses who had seen a prison murder. Year after year, each of those eyewitnesses recants, right? So when the first eyewitness recants, he goes in, he presents it to the court, and the court's like, yeah, but there's still like 4 more, too bad. So then when the next witness recants in the next years, he goes into court, and the court says, well, first, you've already had an appeal, too bad. And then also there's still some other people. But eventually, everyone is recanted. There's no evidence left to convict him. And because of that, his actual innocence served not only as a reason for him to get into the court, the Missouri Supreme Court said in the Missouri Constitution, it was a reason for him to get out of prison, right? Because there was clear and convincing evidence of his innocence. So great, right? Like actual innocence, claim in Missouri, sounds rad, but maybe not. So in 2016, we took the case of our client, Rodney Lincoln, up into the Western District. Mr. Lincoln had been convicted based on an eyewitness identification made by a traumatized young girl who had survived a horrific crime, and also a hair that they said was his at the crime scene. DNA testing showed the hair was not his. The victim, now a 40-year-old woman who has other corroborating evidence, has come forward, recanted her identification, and there's other evidence that shows that her initial identification was flawed. So we go into court and we say, just like Joe Amrine, there's no evidence to convict Rodney Lincoln. You couldn't even arrest him today, right? But the Western District said, because the Missouri Supreme Court had only recognized a freestanding claim of actual innocence where the death penalty had been imposed, they're not at liberty to expand it. Essentially what they're saying is innocence is a claim in Missouri right now, but only if you were sentenced to death. And that has been sort of the state of what we have been fighting and dealing with in Missouri now, most particularly this was in 2016, but for the last 3 years in the case of 2 other clients that I'm going to talk about in our last few remaining minutes. But so in Lincoln's case, this was Mr. Lincoln. The court says, in short, no matter how compelling his arguments may be, we are constrained to offer relief only as authorized. Threw up their hands. Now, while the courts didn't provide relief, there is I wouldn't say a happy ending, but there is a more positive ending to Mr. Lincoln's story, which was shortly afterwards, on June 1st, 2018, which was Eric Brighton's last day in office. He commuted Mr. Lincoln's sentence and he is now home, but he is not exonerated, right? Because essentially the court has thrown up its hands to say, we don't know if innocence is a claim unless you are sentenced to death. But so innocence, maybe it's a claim, we don't know, but what if a prosecutor agrees that someone is innocent? Surely, if the very office that convicted someone says that the defendant is innocent, they must come home. And this is the particular issue you're seeing coming to a head in Missouri. And you can see it all across the news, all across the networks who are covering the cases of our client Lamar Johnson, who we represent with Lathrop, and Kevin Strickland. So Lamar Johnson is convicted in 1996 of a murder. Essentially, there are 2 people sitting on a porch. It's dark out. 2 black men wearing ski masks that covers everything but their eyes and the hole around their mouth come up to the porch. There's a struggle, and one of the men dies. They run off. The survivor is a man named Greg Elking, who tells police originally, I have no idea who did it. Couldn't see anything, right? Which we all believe. It's dark out. They're wearing masks. That makes sense. But essentially, the police then say, he has a conversation with the police where he's like, well, you know, if you want to tell me essentially who I should pick, I'll do that if you help me out. And so Elking picks Lamar Johnson after being told that that's who had committed the crime by police. And in exchange, he receives over $4,000 of payments that are never disclosed to counsel. In addition, there's a jailhouse informant that comes forward and testifies, and not all of the information that is there is accurate. And Lamar Johnson himself had an alibi for where he was when this crime occurred. He was over a 10-minute drive one way away, 3.5 miles, where he was accounted for all but 5 minutes when he stepped out of the house. So it would have been a 20-minute round trip. He could not have made it there and back. But an officer got on the stand and testified that he had made that drive and that in fact he could have done it. So based on these sort of misconduct pieces, Lamar Johnson is convicted. Fast forward in time. Greg Elking comes forward, and what you see here at the top left is a letter from Greg Elking to his pastor saying, I did it wrong, right? I didn't believe it's the right thing to do then, and now it's on my conscience that I identified this person that I don't know if they committed the crime or not, and in exchange, I received payments. In addition to that, the real perpetrators have come forward and confessed, explaining their motive, explaining everything about, and showing that Lamar did not commit this crime. Lamar gets all of this information while he's incarcerated. The affidavits come to him. He hears from Greg Elking, gets an affidavit, and he goes to the court over and over again and says, I am actually innocent. And they don't even have a hearing for him because, again, he's procedurally barred, right? The issue isn't, are you innocent? It's, do you have a right to be in court? Well, when Kim Gardner was elected in 2016 as the new prosecutor in the St. Louis Circuit Attorney's Office, we presented this case to her and said, we've been looking for these things. And over the last 10 years, we asked over 10 times for records of payment to Greg Elking. And we're told no such records exist and no such payments had ever happened. She gets in office, she starts her investigation of his case, and looks into her file and finds, as you'll see down here, the ledger of payments that were made to Greg Elking, as well as a number of tickets and other things that have been taken care of for this witness who I had testified against Lamar and who had also recanted. Her conviction integrity unit files a whole large report, and she decides he's innocent. I have an obligation to bring him home, right? So prosecutors are ministers of justice, and they're not there simply to convict, but to do justice. And so when there is someone who is innocent, they have an obligation to fix it. So fast forward to 2019, Kim Gardner filed a motion for new trial. In that motion for new trial, she says, here's all this new evidence, he's actually innocent. The rule for a motion for new trial is that it must be filed within 15 days, or at least it says that specifically for the defendant, and the defendant can also ask for an additional 10 days. At that time, the circuit court also appointed the attorney general to represent the state. The circuit court denied the motion for new trial. It went all the way up on appeal. And essentially in 2021, earlier this year, the Missouri Supreme Court held that a prosecutor cannot file a motion for new trial. There is no right at that point for a prosecutor to correct an injustice. And what that means is Lamar Johnson, again, no one is saying he's not innocent, is still sitting there, because the question is he procedurally in the right court, and what can he do? So at that point, they said, well, the defendant can file a habeas petition, which is what we are pursuing, but it's up to the defendant, right? He's got to do that. Now, the caveat is, in a habeas proceeding where the defendant files, the responding party is not the prosecutor. The responding party is the attorney general, because it is a suit against the warden. You're saying I'm being held unconstitutionally. So it creates this issue where a prosecutor can be saying someone is innocent, and yet he's still there. So Lamar's that motion for new trial was filed in 2019, and he's still waiting. But he's not the only one. Fast forward to the other side of the state now, and we can look at the case of Kevin Strickland. So Mr. Strickland was convicted of a crime that occurred in 1978. This was a horrific triple homicide where the fourth person who was injured survives, tells the police when they arrive that 4 men came in, identifies 2 of them that she knows by name, does not identify Kevin Strickland, who she knew, did not give his information, instead gives a description that later in time, someone else came forward to say, well, doesn't that sound like Kevin Strickland? And then that's sort of where the identification came from. That's the evidence they had against him. He had an alibi. You can see this was the crime scene the night of. A number of people were there talking about it. So everything was sort of getting convoluted at that point of who was saying what. And what happens then is Mr. Strickland goes to trial. First trial has a hung jury. Second trial gets convicted. And 3 months after his first trial, his co-defendant, Vincent Bell, is at a plea hearing. And in his plea hearing, where he has to allocute, he gives a complete description of what happens, names every other individual who committed the crime with him, and says, Kevin Strickland was not there. He is actually innocent. And over time, 2 of the other co-defendants have come forward and also said that Kevin Strickland is not there. And the victim came forward to recant her identification, which now we also know under new science of eyewitness identification would have never been admitted in the first place. So this year, in May 10th of 2021, the prosecutor in that office, James Peters Baker, had reviewed the case and said, I think he's actually innocent. So on May 10th, we filed a habeas petition directly to the Missouri Supreme Court. Typically, you would file that in the circuit court first, but you can file in a higher court if you have good cause and they have original jurisdiction. And we said the good cause is Mr. Strickland's claim, his strongest claim here, is that he is actually innocent. Everyone agrees. The prosecutor agrees. And not only does she agree, she had the U.S. Attorney's Office take a look at it, the Kansas City Board of Police Commissioners took a look at it, and other judges took a look at it. Everyone agrees. He's innocent. He needs to come home. And the only court who can clarify after Rodney Lincoln's case that innocence is a claim if you are not sentenced to death is the Missouri Supreme Court. So we're coming straight to you and you need to clarify it. Well, 3 weeks later, on June 3rd, the Missouri Supreme Court denied that petition without any explanation. We have now refiled in DeKalb County. But again, we're beginning that process now where the argument is going to be, are we allowed to be in court? The prosecutor is not the responding party. And that is the question. How can it be that innocence itself is not enough, right? And these are the parameters under which we are operating. The sort of coda to this story, and I know my time is up, is that This last year, after Lamar Johnson's case came down, the Missouri legislature took this on and did pass a law that will allow a prosecutor to file a motion for new trial. It will give the attorney general notice. They'll be able to ask questions, but it will the prosecutor will be the responding party. That bill, if it's signed by the governor, will go into effect on August 28th. It is not yet signed. August 28th is still, months from now. And Mr. Strickland, who's been in for over 43 years for a crime he didn't commit, is still waiting. So, I wish I had a happier ending for these. I promise you that Lamar Johnson and Kevin Strickland will come home, but I think it is such a testament to the technicalities of the system that we use to keep people incarcerated, and the understanding of that until we fix that for everyone, our criminal legal system will still not be just. So, thank you.
Wow. Thank you so much, Tricia, for being here with us and for talking about this important work that you are doing. Thanks for spending the time with our clients, colleagues, and friends. Before we move on to our next and last presentation of the day, I need to share our Kansas CLA code with you. The code is LGPM 2021. Note, this is only for attendees who are seeking CLE credit in Kansas. I'll repeat that again. It's LGPM 2021. We'll now be moving on to our last topic of the day, everyone's favorite, ethics. I would like to introduce our next presenters. Peter Daniels serves as the General Counsel to Lathrop GPM, where he focuses on professional responsibility, conflicts, risk and loss management, and managing other firm-related legal matters coordinated through the Office of General Counsel. For the past 15 years, Peter has advised lawyers on ethical issues and duties, including responding to subpoenas, preparation for testimony, and importantly, avoiding malpractice. Prior to his role as general counsel to the firm, Peter practiced in the fields of product liability, professional liability, premises liability, transportation, litigation, toxic tort, personal injury, wrongful death, and commercial litigation. Bridget Romero is a partner in our labor, employment, and higher education group, and her practice is focused exclusively on employment and labor law. She regularly counsels business owners, HR professionals, and in-house lawyers on a full range of employment matters. Bridget also defends employers in litigation, drafts employee handbooks, and conducts workplace investigations. Since 2014, Bridget has also served as the firm's personnel partner. In this role, she's responsible for developing prevention policies and procedures, as well as managing the firm's employment issues as they arise. I'll turn it over to both of you.
All right, good afternoon. Hope if you could start with our first slide, that would be great. So we entitled our presentation Law in the Time of COVID, which is a reference to the movie Love in the Time of Cholera, which I haven't really ever seen the whole thing because it involves a bunch of sweaty people vomiting, and that doesn't seem like entertainment to me. But what we thought we'd talk about today are the topics covered here, which are basically how we continue to practice law, partially because we're still in a partial COVID environment, but then also because the practice of law is obviously going to undergo a change here as a result of COVID. As we begin to come back, many of our colleagues are already back in the office or have never really left. We're going to have more of a distributed practice of law is the phrase that I've been using, and want to discuss with you a couple of those topics that seem to be most of concern, perhaps from the standpoint of a general counsel and a personnel counsel, but for all lawyers too, who manage other lawyers, including younger lawyers and then also manage staff. So next slide, please. I got this email from somebody within our C-suite, I won't mention who, and it made me laugh out loud because he was intending to give an out of the office, but it kind of got truncated because really, what are we out of when we're working from our homes or our coat closets, our basements, maybe the lake house if you're lucky, or the lake cabin. But it made me laugh when he said, I will be away from this afternoon. But that is kind of where we're at. What are we going to be away from? How are we going to deal with it? what are we going to do about supervision, competence, diligence, and communications? Next slide. We put together, and what's going to happen is the quiz will come first, and then we'll discuss the concepts, and then we'll share with you what we think the answers are. And I apologize for reading our quiz question to you out loud. I don't like it when people read to me, but perhaps not all of you are participating by watching the cameras, and so I will read it, and I'll read the questions. So Susie Lawyer is an estates and trust lawyer. She's admitted in the state of Missouri, and her house is in Missouri, but she is admitted in the state of Missouri, and her office is in Missouri, but she lives in the state of Confusion, which is immediately next to Missouri. And she has a beautiful house in a suburban lake with a dedicated workspace that has a separate ground level entrance and room for parking without blocking the driveway. During COVID, her firm asked her to work from home, and it turns out she is far more productive. She saves an hour of commute time. She has far fewer pop-in distractions, and it's improved her attitude because it's not such a struggle to get to her kids' activities. First question is true or false? Susie is not at risk of violating the rules prohibiting the unauthorized practice of law because her work from home is temporary. Next slide. Quiz question 2. Once vaccinations became consistently available, Susie started meeting with clients that were also working from home, including neighbors that she had never really met because they were all also always working from their offices and weren't around at the same time. Question: Susie is in violation of the rules prohibiting the unauthorized practice of law because she is meeting with clients. Next slide. Starting in September, Susie's firm asked all lawyers and staff to return to the office full-time, but she's decided to stay in the state of Confusion where she lives. She gave up her office in the tower, got new business cards listing her home address, and regularly now meets with clients from her home office. The firm sends all her mail to her home and provides a full computer, printer scanner, and updated the firm's website to note she works in the state of Confusion. Last couple questions. True, false? Susie is participating in the unauthorized practice of law. Next question. Except for Mark, who we'll discuss later, the other partners in the firm are all still come to the office, so they have nothing to be concerned about with the Office of Chief Disciplinary Counsel. And the last question, if Susie was an in-house lawyer providing 100% of her legal services to the entity that is her employer, it would not be a violation of the rules against the unauthorized practice of law. Next slide, please. Really, the starting place and the most significant analysis of this question is done under Rule 5.5. Rule 5.5, which is lengthy, and so we didn't include it in a slide deck for you, is the rule on unauthorized practice of law and the multi-jurisdictional practice. Probably as a result of COVID, but certainly well-timed, the ABA came out with a formal opinion number 495 in December of 2020. In essence, it says, don't act like you can practice in a location where you're not licensed. Don't advertise. Don't hold yourself out as having an office. Don't offer or provide legal services in that location. Websites, business cards, and advertising approach a bright line violation if you indicate to people outside that you are able to practice law in the location where you are sitting as opposed to where you're licensed. The ABA opinion includes a broad caveat, and that is that lawyers providing temporary services when associated with a license or pursuant to Pro Hoc Vici rules are allowed to do so if they can do it previously, they can probably still do those things from home. And next slide. There are some specific guidance. There's a lot of states that have not provided specific guidance, more states than have. Florida has a recent opinion that people have in our world have pointed to. where a New Jersey licensed lawyer was allowed to work from home in his home in Florida, as long as, and again, it hits the key touchstones, he did not hold himself out as a Florida lawyer. He does not meet with clients in Florida. This particular ruling was a little bit narrow from the standpoint that he was also exclusively practicing federal intellectual property law and not Florida law. The broader application would be he should not be practicing any Florida law at all. The practice of intellectual property being largely a federal practice, there are exceptions to it for multi-jurisdictional practice that are a little bit beyond the scope of our presentation, but you should be aware of the potential limitations of that authority. The District of Columbia had an opinion that kind of went at it the opposite way. It said that DC resident lawyers, so people working in the District of Columbia, can temporarily work at home due to COVID and not be in trouble with the DC bar. Even if they're not licensed in DC, they can do that as long as it is incidental and temporary, and as long as they continue to maintain an office where they are licensed, that they don't hold themselves out as licensed in the District of Columbia, and that they don't host regular meetings. Next slide. Some states, really unrelated to COVID, have also stated opinions with respect to the practice of lawyers who are not licensed in their state, but working from their state. And I've cited a couple for you here. There's a Maine ethics opinion, obviously before the time of COVID from 2005, that discussed basically that Maine did not have an interest in regulating lawyers who were not practicing in Maine. In other words, if you're a New York lawyer, a Missouri lawyer, a Kansas lawyer, but you have a home in Maine, you can practice from that location as long, again, as you're not acting like a Maine lawyer. Utah has a similar opinion from 2019. They indicated they're not interested in regulating an out-of-state lawyer with a private home in Utah. New Hampshire has a similar comment. Minnesota, you can live in Minnesota and practice federal law or tribal law of the state, or I'm sorry, tribal law, as long as you are licensed in some state. You can do those things for Minnesota. Arizona is similar to Minnesota. And I would mention there's an excellent article addressing this written by Richard Rosenzweig in the ABA Journal from August of 2020. I should also mention that, and here's the answer to the quiz, and it may be somewhat surprising, but you can get in trouble not only with the state where you are practicing but not licensed, but also with the state where you are licensed. States will use reciprocal punishment, if you will, and a state where you are practicing but not licensed has additional interest in prohibiting the unauthorized practice of law, because it's sometimes also a crime to practice law in a state where you're not licensed. Those laws are generally more often intended for people who are on the fringes of practicing law, either offering wills and trusts or collection type services, but it applies to lawyers just as well. So you should be careful. You can be disciplined in either state where you are licensed or the state where you're not. In terms of our quiz questions, next slide, Hope. It's probably true, assuming the state of confusion has not specifically prohibited, as long as Susie is acting on a temporary basis, as long as she's not holding herself out, she is unlikely to be in violation of the rules against unauthorized practice of law. As we continue to come out of COVID, I think you're going to see more and more guidance on that. And I think that the focus is going to be on the question of temporary. With respect to the second question, although it is still temporary, Susie is now meeting with clients that live in the state of confusion where she is not licensed. And the nature of estates and trust law tends to be pretty particular to the states, although there's some federal tax implications, obviously, that relate to it. A lot of it is state law centric. And by now meeting in her home in the state of confusion with residents of the state of confusion and probably practicing estates of trust law that is governed by the law of the state of confusion, she is probably practicing law, even though it's temporary. If she is doing it on a regular basis, she's at risk of being found to be unauthorized practice of law. And as you can see, as we built the hypothetical in question 3, now she's really stepped over the line, because her advertisements, her business cards, her presence on the website, everything else is pointing to the fact that she is now in the state of confusion and practicing in the state of confusion. As close as a bright line can be to rules that apply to lawyers, that's probably it. You should not do that. And there are numerous decisions, one from California and there's one from Minnesota, where they come down very hard on lawyers who appear openly to be practicing the law in a place where they're not licensed. I think when I mentioned too the pro hoc vici, I will throw in too that you should be aware that if you are a resident of a state, many states have a rule, California being one, North Carolina being another. If you're a resident of the state of California or you're a resident of the state of North Carolina, but you're not licensed in California or North Carolina, you cannot pro hoc vici into those states. In other words, you can't get around the California bar by living there, but pro hoc vici admission into the courts or admin law systems there every single time to avoid joining the California bar. So in summary, or quiz question 4, rule point 5.5 prohibits assisting others in the practice of law. Does anybody else other than Samuel have difficulty hearing? Raise your hand, ping, something. Hope, let us know. Okay, thanks. So Samuel, sorry, if you'll contact us, we'll send you the notes. So question 4, probably false. Lawyers cannot assist others in the unauthorized practice of law. So the other partners in the law firm back at the tower who have assisted Susie by changing the website, giving her business cards, allowing her to stay at home without being licensed in the state of confusion, are themselves subject to discipline by the state authorities. And then finally, I can't do a Marissa Tomei accent, but the 5th question, as it applies to in-house counsel, is a bit of a trick question because it depends on where you're practicing. Some states treat in-house lawyers differently. Some say that they aren't really required to have a license. Some have a special license for in-house lawyers. And so you have to be particularly aware of the states where you plan to sit and work on behalf of your full-time employer. So with that, I will turn it over to Bridget, who are going to discuss another set of concerns with respect to distributed practice.
Thanks, Peter. Hello, everybody. Thanks for being here today and for joining us. Before we get into the next several slides, one just quick addition on the estates and trust question, because Peter mentioned tax. The other issue that comes up, and neither of us are tax lawyers, but it certainly comes up in the world of employment law and wage withholding and payroll tax and doing business in different states. You should just make sure you're aware there's a whole host of tax issues around, having your employees live in one state and work in another state, or vice versa, depending on where the work location is. So certainly something to be aware of. Many states have sort of adopted these reciprocity rules and tax forgiveness rules and things like that. And again, we are not tax lawyers, but just issue spotting for you.
And there's others. Workers' compensation insurance would be another one.
Yeah.
I mean, if people are not working where their offices are located, you have to make sure you have the right insurance in place. So
yeah, great point. So, all right, we are going to talk about lawyers, but also cats and birds. And I get to share some hypos with you related to Susie's partner, Mark. And so Mark is licensed in Missouri and lives in Missouri. He, however, isn't so much of a litigation lawyer. He's an M&A lawyer, and he works on big deals with 3 to 5 lawyers, including associates and contract attorneys, paralegals, analysts, multiple LAAs. He flat out has said, I'm not coming back to the office ever. He's not on the management committee of the firm. He's not assigned an associate as part of the firm's one-to-one mentoring program, and the firm has a very experienced and competent HR manager. Quiz question number 1, true or false? Mark does not have to worry about the associates and staff because other people in the firm are responsible for all that stuff. Quiz question number 2, true or false? Being off-site is a huge advantage because Mark has an unpublished home number, no cell phone, and doesn't have to worry about being interrupted by clients and others all the time. Slide. Here's a little bit more on Mark. At the start of the pandemic, Mark had the firm bring to his home a computer and a wireless printer and scanner. At first, he connected through a home router, but he found out his neighbor's unsecured Wi-Fi was much stronger, and so now he connects through that. And the firm did not have at the time a portable shredder to provide him to put his drafts. And so he puts those items in the kitchen trash can, which the cleaning service then retrieves and places in a common dumpster. From time to time, his wife and grandkids are over and the housekeeper, and they all use his firm supplied laptop for internet shopping and playing games. They promise they don't get into anything else, but they do use it for those things. Slide. So quiz question number 3, true or false? Mark is okay to link by Wi-Fi to his neighbor's network and throw away drafts of documents because it goes to a common dumpster. Quiz question number 4, true or false? Working from home means the rules of decorum are waived. Slide. All right, just to make sure all 161 of you are paying attention, it looks like the chat function is open. So why do we have a picture of a cat up here? Don't all respond at once. Because I'm not a cat. Good. I'm not a cat. All right. Many of you are getting this. So for those of you that lived under a rock, just kidding. By now, we all know there was a lawyer in Texas because it's literally known now worldwide amongst everyone who has nothing to do with the law. That there was a lawyer in Texas who was attempting to join a court conference virtually and had a cat filter on. And so he was appearing in the conference with the judge as if he were a cat and the cat's mouth was moving. And so who can remember another favorite? I'm not a cat was my personal favorite line from that video, but there's another really good one. And so I want to see if anybody can throw that up on the chat again, we got to make sure you're paying attention here for your ethics hours. So there's another great line from it. Let's see if anybody can come up with it. I'm not a cat. He tells the line I'm thinking of is something he says to the judge. I'm using my secretary's computer and her daughter was using it. Yeah, he tries to, there you go, Cynthia, Rhett, you got it. I'm prepared to proceed. He basically says, I'm here in person and I'm ready to go. I'm ready to proceed. And to me, that's just hilarious because his little cat face is moving as he says he's ready to proceed. How well can you serve your client when you are appearing as if you are a cat saying you're ready to participate, ready to proceed? So great. Thank you all for chiming in. James, you're allergic to cats. I think he's probably allergic to filters now at this point. All right, so we'll unpack that a little bit more here in a minute. Next slide. This one was not as widespread in its reporting, but who knows why. We have a bird up on the screen. Again, just throw up your ideas in the chat. This was a less widely reported story, but nonetheless, pretty well reported, at least among lawyer circles.
Or maybe not as much as we thought.
Maybe not as much as we thought. It's a colloquial way to refer to sort of a gesture that you would give, that you would use towards another person with your hand.
And just one finger of it, actually.
The guy who got a little animated in court and then denied he did it. You got it, Patty Silva. Good job. Yep, got lots of flipping the bird. That's it. So for those of you that may not have read this, there's a lawyer in Michigan who was listening to some appellate arguments on a case where he was representing a plaintiff in a med mal matter, I believe. And he was not arguing the case, but wanted to listen in. And so again, he's the plaintiff. At the time the defense counsel is speaking, his screen is blank, so he can't see. He can apparently hear, but he can't see anything. So he is flipping the bird using his middle finger, if you will, towards the computer screen. And apparently that can be seen by the judges and the other parties appearing for this appellate argument. And he ends up getting fined $3,000 for doing this. And I thought I would just read to you the quote from Judge Thomas Cameron, who wrote in an order fining him the $3,000. Mr. X exhibited shameful disrespect to the court and to opposing counsel in his offensive gesture, and key here, this is important, in his dishonest replies to the court's inquiries. So who knows what it is that he said he was doing, why he was flipping the bird? Who knows what excuse he gave? At least according to Judge Cameron, it was an excuse and it was not believed. He said that he wasn't in fact being disrespectful to the other parties or to the judge. He's a 74-year-old man, been practicing for 40 plus years, and he would of course never do that, was his explanation, that he wouldn't do it, but he says he was doing something else. Who knows what that something else was? All right, people. Mad at his laptop. Yeah, he was mad that his computer was, quote, malfunctioning and that he wasn't able to see, and that's what he was flipping the bird about. So suffice to say, the judges did not buy it and went ahead and issued him the $3,000 fine and really sort of invoked yet another rule, which we're not going to talk about today, candor towards the tribunal, an ever-present, ever-important rule. And so don't forget about that one. All right, so next slide, please, Hope. What do the stories about Mark and the cat and the bird have to do with the virtual practice of law? Well, in summary, the virtual practice of law, we've all come to realize, implicates our core ethical duties. And those really are competence and diligence, communication, confidentiality, and supervision. And they exist all the time. They've existed all this time, but many of them have come to be highlighted through our virtual practice. And so just to sort of get back to basic and level set, Rule 1.1, and these are all references to the ABA model rules. Just as an FYI, we all know that many states have their own rules, most of which mirror the ABA model rules, but these rule number references are to the ABA model rules. So Rule 1.1, a lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. And then Rule 0.13, a related rule, a lawyer shall act with reasonable diligence and promptness in representing a client. So again, these rules are ever present, existed back in the days when we were all mostly in brick and mortar buildings, but some important things to note here. The comment 8 to Rule 1.1 says that competence includes the benefits. You must keep abreast at all times. You must stay current, and that includes understanding and knowing the benefits and risks associated with relevant technology. Next slide, please. So there you can see that third bullet point in quotes that comes from the comment to the rule, and that same comment and corollary to the rule is highlighted in an ABA formal opinion that I don't think we've mentioned yet, not to be confused with the one Peter mentioned, but this one is ABA Formal Rule 498. that was actually just published a couple of months ago on March 10th of 2021. And the title of it is Virtual Practice. It's about an 8-page document that's probably worth your time. So, you know, you've got to stay up to speed. There's really no excuse. And, you know, I just am not good at technology. I've never been good at technology. I don't get it. You know, those excuses, I think, are pretty clear, are not going to fly. For those of you, I know we have people from all over, but for those of you who happen to be Kansas lawyers, the disciplinary administrator issues refreshers from time to time, and they issued one not long ago, just in the fall of 2020, with the fact pattern. Whether it was based on reality, I don't know, but fact pattern was, again, an M&A type lawyer who wasn't familiar with Zoom and hadn't had to be on a lot of court conferences, but was going to be involved in a matter that did require appearing by Zoom with the court. And he had asked that the hearing be held in person. He made a motion and the court denied the motion, you know, and said, nope, you can't do that. And in fact, cited the Kansas equivalent of Rule 1.1 and the corollary comment about being current on and keeping abreast of all the changes that happen with technology and law and practice, including the benefits and risks associated with relevant technology. So their bottom line summary, there's not going to be an excuse about I don't get it or I don't know how to do it. Another couple of tips on competence and diligence. You know, good idea to just plan touch base meetings with your teams. Make sure everybody knows what everyone else is doing. Continue to have multiple people on deadlines. You know, I think most of us probably still get our deadline reminders electronically, but there's some you know, in-house departments or firms perhaps that still do use paper system reminders, and those are obviously going to be much harder to get if you're not in the office. So just double down on your deadline reminders, and then, you know, log on early to any court appearance or client meeting or witness interview. Log on early through whatever platform you're using to make sure, you know, you understand how to, you know, operate the camera, the mute button, you know, your sound, microphone, all of that. You know, as many times as we've all used these platforms now, I'm still amazed at how, you know, this court's version somehow looks and sounds a little different than this one, or this client's WebEx has this different feature than this other client's. So, you know, Peter and I, for example, got here today early, and it's a good thing we did because the original plan didn't come to fruition, technology. So we had to pivot and figure some things out. But you know, so anyway, it's just the moral of the story is plan ahead. Make sure you've tested and retested, particularly if it's something where there's a set appearance time and you don't have a choice about it. You know, it's not something that you can just say, let's reschedule. All right, next slide, please.
Before you go on to
Yeah.
that, if you don't mind, Bridget.
Please do.
Rolling back to a prior slide, being very aware of how things like the new trials are going to work, how witnesses are going to be presented. Are they going to be allowed to be presented by Zoom or virtually, or will all witnesses have to be present live? Clearly could be differences in the criminal context from the civil context, but just the point of you have to ask these questions before you show up. Maybe that's obvious, but understanding well in advance the technological differences in a courtroom where you may be, some of our lawyers have tried cases now outside of courtrooms because there was a perception that there was more space available, for instance, in a rented ballroom in a hotel, and knowing in advance how that's going to impact your presentations because some of the systems that are normally there are not present, how they're going to record bench conferences, how they're going to separate the jury for deliberations, all that type of thing is different when you're going to try a case in today's world. So understanding those competencies, and then very simple things that can apply not only to the litigation practice, but elsewhere, like how can we get remote signatures that are going to be valid? States have adopted different methods and different practices for allowing virtual notarized signatures, and you need to be aware of your states where the signature is going to have an impact where it's going to be tested what the state's rules are in that location. And it's really a state-by-state determination. There's not a federal compact on that, at least not yet.
And great point. Also, before we leave this slide, a lot of jurisdictions and localities had told statutes of limitations because of the pandemic, had delayed CLE requirements, deadlines, and all of those things. And many of those have now changed and reverted back to what they were, but it varies widely. And so if you're in-house counsel and you have offices in multiple jurisdictions, make sure you're checking on all those things. And if you're, practicing at a firm or elsewhere and representing private clients, obviously same rules apply. You can just, you can't check. There's no such thing as checking too many times, because it's changing frequently, particularly on these issues. And so when in doubt, look it up and look it up again, but right before you pull the trigger. Are we supposed to provide the code word somewhere? I think that's probably somebody asking about the Kansas code. And I think that a survey question will launch automatically that you'll need to then reply there. I don't think you just do it in this chat. So if I'm wrong about that, Hope or Aubrey, feel free to speak up, or Catherine, but I think that's how that works. So just stay tuned and keep looking at your screen.
Sure.
Okay, thanks, Aubrey. All right, next slide. So confidentiality is another rule that is really important, ever present and always important, but again, underscoring the importance now. So this is Rule 1.6a, and then part of Rule 1.9, which applies to former clients. And so the rule reads, a lawyer shall not reveal information relating to the representation of the client unless the client gives informed consent or the disclosure is impliedly authorized to carry out the representation or the disclosure is permitted by law. So, this duty is extraordinarily broad. Even things like talking about a client that you represent by name is implicated by this rule. Even if you're not discussing a matter or a particular issue, you're not disclosing any attorney-client privileged information, you're just identifying a client by name, that would be implicated by this rule. So it's much broader than what many people assume. And it encompasses much of what we hear regularly from people, out and about in society, in bars, at the pool, in the coffee shops. If you're a lawyer and you're having those conversations, work conversations, you just need to be extraordinarily careful. And I think we're all, practicing law in a multitude of locations more than we certainly used to. We've all, been mobile to some extent for a long time now with cell phones, but, more and more, I think conversations are happening in places that they didn't used to, and we just need to be really mindful of this rule.
The reference to the cell phone, hands-free phone in the parking lot is a true story. I was preparing for a trial, actually hearing up north, and there was a criminal defense lawyer in a bright red car having a very animated conversation clearly with his client through the hands-free function on his car. The car was off, he wasn't driving. You could hear both the lawyer and the client arguing about whether they were going to take the plea bargain. And unfortunately for them, I wasn't the prosecutor listening to their entire conversation, but I did tap on the window. It just disturbed me to the extent they were having a very loud and public argument and probably didn't realize it, an absolute breach of confidentiality. And I didn't quite get the bird back from me, but I got an angry look and just went on my way. So
yeah,
I tried.
Yeah, well, good for you for doing that, though. It's, I'm always astonished at the conversations I overhear, not from lawyers, but just in general. I'm sure we all are in bathroom stalls and, in line at places. You walk by someone and think they're talking to you, but it turns out they have their earbuds in talking to someone else. So when you're a lawyer, you just have to be all the more careful. Data breaches, you see this bullet here on ransomware, malware, phishing, all of these things are so scary. And probably we're all at increased risk if we're not following the security protocols that our firms and businesses have put in place to protect our clients' data and our firm and business data, when we are logging on at other locations, be that our home or a hotel or some other business. As a general rule, though, I would suggest not doing business, at least if, you're going to be not using, a public password, a public Wi-Fi system or something at the coffee shop, and not really doing, much business in places like that. All right, I think we can move on to the next slide. A little bit more on confidentiality. In the virtual environment particularly, you do have to make reasonable efforts to prevent, it's not just the disclosure that you're doing, even though you shouldn't be because you're talking in line at the coffee shop. It's inadvertent or unauthorized or even unknowing. You just have to be really careful about that. Notes and drafts, some of that was discussed in Mark's hypothetical. Wi-Fi, VPN is currently, at least, it may change, but right now it's the creme de la creme. It's the one you want to be using. And I'm sure many of your businesses and firms have VPN available. They tell you to use it for a reason, so you should listen to them. If you're at home still quite a bit working, and your business or firm allows that, be aware of family members and friends and kids who might happen to be around, even if you're in a secure location in your home, in an office with a closed door. If you have young ones, as some of us do, who are, passing you notes underneath the door from time to time, or, you want to just get them to be quiet, and you grab a piece of paper on your desk and flip it over and say, draw a picture on this and be quiet. Well, if that piece of paper was a client matter, and then the kid disappears with the paper, that's a problem. So just little things like that you may not have at the forefront of your mind, be aware of, and take extra precautions. I don't know if there's anything else you want to add on that.
Not particularly. There's been some stories, perhaps apocryphal, about Alexa and other active listening devices in your home, the smart devices that have opened up phone communications inadvertently so that lawyers are participating in conversations that are being inadvertently heard by other people. I don't know how true that is, but it is a recommendation of the practitioners that if you have those devices in your home, to disable them while you're working if they're in the location where they can pick up on what you're saying.
Great point. Great point. All right, we can move on to communication. So this is, another one of the core rules that are implicated in the virtual practice. Again, it's ever present. It's always existed as a rule that we all need to follow. And I think Peter will have to correct me if I'm wrong on this, but it used to always be that the number one complaint that gets lodged against lawyers with disciplinary offices is implicating this rule about communication, that I can't get my lawyer to call me back. I don't know what's going on in the matter. I don't know what's going on in the case. So to the extent that is still the case, or it remains at least among the top complaints that go to disciplinary offices about lawyers, the virtual environment perhaps makes that even more challenging for some. Perhaps for others, it's, they're doing better. I think that may be a personality thing. But I've had some clients tell me, now that we're virtual, I can't get my staff person X to respond to my calls. They think all of our communication has to be by message and chat and text. I can't get them on the phone, and there's just certain things I need to explain on the phone. And I think the same goes with, communications with clients. There are certain things, and certain clients, obviously it's a matter of preference. But it's not enough just to send a communication and have it go into a vacuum. You need to make sure there's dialogue, that you're discussing strategy, and that there's a clear understanding if goals and objectives have changed because of the pandemic on a matter, which in many cases they have. Businesses have had to pivot and adjust their resources, as all of you I know are keenly aware. So again, just over communicate and find the way that works for you and your clients. But I do think we all need to remember to do some live communicating from time to time. Next slide. I think this is just a good sort of summary slide that some of which is, related to the virtual workspace, but many of these are just good rules to live by in general. Inform clients of good news promptly and bad news just as promptly. Take the sting out by communicating it when you know it. and give time to, to respond and process and come up with a solution. And, there's just the virtual office environment isn't going to be an exception, just like the technology isn't an exception according to the judges and courts and ethics officers out there. We're not going to get a pass on not communicating appropriately just because of being virtual. I think setting up, the other thing that comes to mind is document management systems. And to the extent our businesses and firms have preferred document management systems like FileSite or others, I think many times when people are working on home with home Wi-Fi or whatever the case may be, you might be slow, you can't get something to save right, you can't get it saved on the document filing system. So then maybe you just decide to save it locally, and then that's where it stays and sits. So those would be the types of things, just to really be careful about, again, implicating confidentiality.
Ready to talk about supervision?
Yep, let's do it.
Another one of the key principles, and Bridget made the great point, this hasn't changed as a result of COVID, hasn't changed as a result of a distributed workplace, but it's certainly greatly emphasized and brought to the forefront because we don't have people around us. We're not walking down the hall, we're not seeing them in the coffee room, we're not riding the elevator, and we're not just dropping in and having casual conversations. And so you just absolutely have to be deliberate about how you supervise. And again, looking to the rules for the basic guidance, they're found in Model Rules of Professional Conduct 5.1, 5.2, and 5.3. And I think the primary focus for this discussion, at least, are rules 5.1 and 5.3, which are structured somewhat similarly. I'll touch on 5.2 just to get it out of the way. It's the rule that provides that subordinate lawyers also have ethical duties, but if there is an arguable question, a subordinate lawyer is absolved to an extent if the supervisory lawyer overrules them on an arguable question of professional conduct. So the real focus should be on 5.1 and 5.3. 5.1 is management and other lawyers' duties to supervise other lawyers. And it's not a great surprise. If you're in management, if you have any kind of a management or supervisory role over other lawyers as a part of a firm or other structure, then you absolutely have a duty to make sure that everybody else within the organization is in compliance with the ethical rules. And the ways to do that are through training and being accessible and having policies that are available and understood, and from time to time, as necessary, distributed. 5.3 are the duties to supervise of lawyers to supervise what the rule calls non-lawyers, even though people don't like being described by what they're not as opposed to what they are. That's what the rule uses. It uses non-lawyers. And so that's what we'll discuss. And again, the duties don't really change because we are working in a distributed fashion or working remotely. In fact, they may be even increased because we have to make sure that the people that we supervise who are non-lawyers understand at least the basic concepts of what we're dealing with in terms of things like communication, things like competence, things like diligence. And so again, how we deal with this, conflicts of interest would be another one, making sure they understand basic timekeeping. We bill our time for the time that's spent on the day that it was spent to the right client at the right time, assisting us in keeping our clients informed with respect to communications, assisting us with keeping up with our deadlines and our due dates and the other things that go into our, our docketing system. Again, how we do this with all of our employees is a matter of training and a matter of policies and a manner of communication and being available to answer their questions, finding out how they're doing, making sure that they have the assets and the equipment they need to do the work. And Bridget touched on communication from the standpoint of communication with clients, but it's at least as important with staff who are not there to be observed. It's not enough, as the slide said, to send emails. In order to supervise, there has to be communication. It has to be a two-way street. It's not enough to say, get it done. Make sure it was done. Who is going to do it? Did it get done? And setting expectations that it's not enough to simply say, do it, so that you can understand and meet the deadlines and be diligent and be competent, so that you don't get in trouble yourself individually, so you don't put the lawyers you're supervising at risk, and you don't get in trouble for not supervising the non-lawyer staff that you work with. So
I think the next slide has some tips, and then we're going to give you some resources.
So basically, the same tips with respect to supervision: increase communication, ask questions, share experiences. One of the things I do when I talk to people in my role as general counsel is at the end of the business that we're conducting, I try and ask a broad, open question, if there's time, and without trying to be too invasive. So what else is going on? And sometimes I hear things that I want to know about, and sometimes I hear about somebody's, problems that are really unassociated with the practice of law. But it helps to have at least one ear to describe those things to. And we have to recognize that people who are working from home, away from their offices, may be subject to a level of stress that we just don't appreciate. We don't know that grandma is at home demanding attention, or that the kids are demanding attention, or the dog, or the other stresses that they're removed from when they are in the office, apart from their being bugged by their cell phones. We can't see those. So just asking what's going on, how are you doing, not just for people we supervise from the staff standpoint, but also the lawyers, making sure we're touching base. Stress, it's well known, leads to mistakes. We forget, we get angry, we get frustrated. So trying to supervise other lawyers, supervise staff people, recognize the challenges that they may have by the distributed workplace, and accommodating that by listening and talking to them and communicating with them.
Related to that, Peter, I think this is a great opportunity to mention. I'll wear my personnel counsel hat for a second. One thing we've done here, and that many of our clients are doing, is reminding employees and lawyers about our employee assistance program and the opportunity to seek anonymous help on a free or very cost-reduced basis to address those issues of stress. Regardless of whether there's any diagnosable or serious condition, stress is something that we all experience, and from time to time. And so, it really does have ethical obligation implications, or it can, as Peter highlighted. And so important to not only check in, but to make people aware of those resources. Slide.
Here's some resources for you with respect to virtual practice. Clearly, this was being developed long before COVID hit. Many of our lawyers have, and lawyer teams really, have worked in a distributed format even before COVID hit, which allowed us to slide into it, maybe some easier than others. But here's some additional resources for you if you're interested in reading on it further. Next slide.
All right, here are the answers, and many of these I think were pretty intuitive and obvious, but again gave us an opportunity to talk you through the rules and highlight why they're important. So the first one speaks to supervision. I don't know if you want to.
Yeah, so the question was basically, does Mark have to worry about supervision because he's not around them, or can he let everybody else worry about all that stuff? And obviously the answer is false. The duties of supervision is the same regardless of where you're working. The fact that you as a lawyer have attempted to check out does not allow you to check out from your duties of supervision, particularly if you're in management, but for everybody too.
So I'll take number 2 as a reminder. Question number 2 was, the idea of being off-site being a huge advantage to Mark because he was going to be more off the grid, if you will, unpublished home number, no cell phone, didn't have to worry about getting interrupted by clients or supervising staff and subordinate employees. And this one we called true and false. It may be an advantage to Mark. It may allow him to hunker down and really get some great work product put out for the benefit of his clients. But it may make him at the same time more prone to not communicating as often as he should. And so probably he needs to, double down on his efforts to understand the needs of his clients and working through what the primary means of communication is going to be in that relationship.
So the next question was, again, probably pretty obvious, but the duties of confidentiality do not change. As a result of working from home, we have at least the same, but probably an increased responsibility to make sure we're using the systems that are secure, that we take care of the draft documents just as you would in the office. If you don't have a shredder at home, or if you don't have a fireplace, at least save them and bring them to the office and put them in the office shredder bin. There are true stories. I mentioned the apocryphal story about the Alexa or the other smart devices, but there are known stories, true stories of people putting their client drafts, settlement discussions and things in their ordinary everyday trash, and through no fault of the fine waste services companies, they end up on the street somewhere and people are picking up things that they shouldn't ever see. And it's a breach of your obligation of confidentiality to your clients. The same would be true of borrowing the Wi-Fi or allowing kids, wives, spouses, husbands, grandma, housekeeper to use your computer.
And then question number 4 was that working from home means the rules of decorum are waived and don't apply. And of course, that's false. A couple of comments here. I have heard recently at a judges panel here in the Kansas City metropolitan area, two judge comments that stuck out to me that speak to this issue of decorum, that by and large, attorneys appearing to their virtual court hearings, if you will, dressed the same as if they were in court and whatnot, but that there were a few lawyers who they noticed had, been less formally dressed than they would have been. And that was noted by the judge. So the comment was, dress as if you would be dressing if you were appearing in front of me. It seems so obvious, but I think it must be worth repeating because it was worth a judge making the point on a panel discussion. And then another judge mentioned something that also stuck out to me, which was that a lawyer was calling in for a court call, and that one, it was okay to call in. It maybe was just a dial in a phone line, but the lawyer was doing so from his car, driving down a highway, and was having trouble hearing, and there was a bunch of background noise, and the connection wasn't good. The cell connection wasn't good. And you could tell that one really bothered the judge. Like she said, it wouldn't be acceptable to not have a clear means of communicating in a court conference normally. So you just, I think many of us and most of us, 99% of the time, are doing things the right way. But, maybe you think I can run this quick errand or do whatever, and you don't make it back in time. And then you get the bad connection with the judge on the call. So that's, probably not doing the best we can for our clients, and just a good reminder to behave as if you were in person, even if you're not. So next slide. When Peter and I are not talking about ethics and other things where people think we're putting up roadblocks when they ask us questions, we are, off enjoying nature. And here, I think this is a photo that Peter's daughter took of him. He'll have to tell us where it was, but I can assure you he was not practicing law while this photo was being taken or on this trip.
One of the coolest places in the world, the Boundary Waters on the border between Minnesota and Canada, that's Iron Lake, and that is a sunrise. That's how early we get up when we go. Next slide. And this is Bridget enjoying her outdoors. I teased her. She sees the world through rose-colored glasses, and this is proof of it. Where are you?
This is actually Joshua Tree.
Very nice.
So, yeah.
So we are out of time. If there are questions, we could grab them real quick, but don't want to be disrespectful of your time. So let us know.
All right, I'd like to thank all of our presenters for sharing their insights and expertise today, and would like to thank all of you for attending. I hope to see you all at our final webinar of the series next Wednesday, June 23rd. The topics will include Supreme Court highlights from the COVID-19 term, which is definitely going to be a highlight of our webinar series, notable developments in intellectual property litigation and advertising litigation, the FTC, competitor challenges, and class actions. Thanks again for your time today.
Before you leave, Catherine, a number of people in the chat want the code, how they enter the code.
I do not know how we enter the code.
Aubrey or
The code, I will give the code again though. It's LGPM 2021.
And it looks like we're hearing from our people here that there will be a follow-up communication with instructions on how to report the code. It will be sent to all of you who attended by Monday.
All right, thank you.
Thank
Thanks,
you.
Catherine. See ya.